Good morning. This is Dustin Hobbs with the California Mortgage Bankers Association, and welcome to the Legal Issues Committee's first webinar of 2020. The committee here produces and presents quarterly, quarterly webinars, and this is our first of the year. So welcome to everyone who's joined us. Before we get started, we've got a lot to unpack today, but before we get started, I wanted to thank our two new sponsors for the committee this year, Hall Griffin and Klinedinst. I really want to thank both Jared Eade with Hall Griffin and Ian Rambarran, whom we'll hear from in just a second, for their long support and now sponsorship for this committee. So again, thank you to Hall Griffin and Klinedinst. And with that, I'll turn it over to Ian to give us a preview of what we're going to hear about today.
Thank you, Dustin. This is Ian Rambarran, everybody. I am an attorney and shareholder at Klinedinst PC here in California and on the West Coast. Today we have a presentation related to what people may have seen in December at the Legal Issues Conference. I thought the conference presentations were great, and this is one of the highlights of that. So I've invited back three of the speakers from the Hot Topics panel at the December conference, and the speakers are Jennifer Gray, who is a partner in the Consumer Financial Services Group at Hinshaw Culbertson, and she practices out of LA. She represents banks, servicers, sub-servicers in federal and state court litigation. Prior to joining Hinshaw, Jennifer was a senior in-house litigation counsel for several large financial institutions. And one of our other speakers is Sanford Shatz. He is an attorney and member of McGlinchey Stafford's Irvine office. Sandy practices throughout the state and is in a part of the litigation practice group and represents clients in California state and federal courts. He's also a member of the Regulatory Compliance Department. And our last speaker from that Hot Topics panel is Fickel. He's a member of Dykema, and he represents financial institutions up and down the state and counsels them on privacy laws, including the California Consumer Privacy Act. And we have another speaker from Ballard Spahr. His name is Andreano. Rich is the practice leader of Ballard Spahr's mortgage banking group and also the vice chair of the Legal Issues Committee. So we'll start off with Rich, and then Dustin Hobbs will go through the legislative report, and then we will jump into the hot topics in class action litigation and other issues. And with time permitting, we will do a Q&A component, and we would welcome everybody to submit as many questions as you can, because we really do have the experts on the phone today. So with that, I'll pass it on to Rich.
Thank you very much, Ian. Good day, everyone. We're going to hit a few key items that the Bureau will be looking at. So if we could first go to the next slide. Hard to overestimate the importance of this rulemaking. January 10, 2021 is the scheduled expiration of the temporary qualified mortgage for loans eligible for sale to Fannie and Freddie, shorthanded the GSE patch. Over the summer, the Bureau issued an advance notice of proposed rulemaking indicating it plans to actually let the patch expire and pivot to something else. Big question, what's that something else, but would provide for a short extension, and we understand the short extension will be coordinated with the effective date of whatever they adopt. Looking at the standard qualified mortgage, it's based on a strict 43% DTI and Appendix Q, which is viewed as having very limited guidance, being very inflexible. Other than that, it's great, but the thought was, what do we do to replace that? And the Bureau looked at it, said it was looking at various things. Do we continue to focus on the consumer directly, or perhaps do we look at loan features, or perhaps even loan pricing? Next slide, let's see what they're thinking about now. Just last month, Director Kraninger sent a letter to members of Congress. She also has appeared before the House Financial Services Committee, made similar comments. Confirmed was looking now to move away from the debt to income construct and move to something as a rate spread construct. In other words, not looking at the consumer individually, but how the loan is priced, comparing the APR to the average prime offer rate. That is a controversial proposal. There are a lot of groups that are against that, including the National Association of Realtors. So very interesting to see what happens there. Still intends to have a short extension of the GSE patch that'll coordinate with whatever they adopt. Importantly, a loan seasoning concept will create a new QM for loans that start out as non-QMs but have continual timely payments for a period of time, perhaps 36 months, and they would then become QM loans. Very important addition. Look for proposals in May of 2020. Now look at the next slide, our friend, the TRID rule. If you didn't get comments in on the assessment, which comment period ended last month, not to worry, the Bureau is still seeking input through surveys on its website. There is the URL. You can go to link to the surveys on their website, or if you just go to their website, you can search TRID assessment and it will bring you to the page. The key for lenders is the loan originator survey. There's also one for loan officers and for closing companies as well. They're looking for a lot of detailed information, really want to establish how much this rule has cost the industry in terms of technology, in terms of time, and overall effort to implement and continue to comply. So what they're really trying to do is build a base to justify cutting back and simplifying the rule. So very important if you put in comments to do that. Next slide. Now let's move on to some HMDA rulemaking that's coming up. Some of it in the HMDA guide that was just released for 2020 just has a couple updated to reflect that they continued the HELOC temporary threshold of 500 in each of the prior 2 years for another 2 years, and the small bank and small credit union small volume, that's less than 500 closed-end loans or less than 500 HELOCs. Basically, they're allowed to report what would be considered the old HMDA data. That's reflected in the guide. But let's move on now to what's upcoming. March 2020, we're looking for final action on what will be the closed-end trigger and the open-end trigger. The Bureau had proposed increasing the amount from 25 in each of the prior 2 years to 50 or perhaps 100, and to set the permanent trigger for HELOCs at 200. This probably isn't much of a big deal for regular mortgage lenders. For non-bank multifamily lenders with closed-end, that's a big thing because a lot of them originate 30 to 40 loans a year. So going from 25 to 50, big for them. More important thing is the July proposed rulemaking that we're waiting for. The Bureau intends to review all the discretionary data points that the Bureau added using its own authority, the free-form text fields, and also should the rule apply to business or commercial purpose loans made to entities secured by multifamily dwelling. In short, should multifamily loans be reported at all under HMDA? Those are the items that we're looking for, again, July 2020. Next slide, this will just show you here are the discretionary points. So all of these are up for consideration in the proposal. If I had to pinpoint one that I think will be modified significantly or cut out, it's there on the top right, the automated underwriting system, which is very difficult to report. And you could also often report the system that wasn't actually used to underwrite the loan. So that's a key one to see modification or elimination. And finally, we'll go to last slide here. And what we can do is the public issuance of HMDA data that was released through policy guidance in January 2019. A lot of criticism that it relied less, rather focused less on consumer privacy and more on letting data out to consumer groups and the rest of the public. Bureau indicated at the time it would revisit the matter. Director Klinedinst had just come on board, really didn't have a chance to meaningfully affect that, so said, I plan to revisit this. Well, we're coming up to the plan to revisit this July 2020, and if you could see what the Bureau indicated, it intends to look at new information concerning the privacy risks and benefits of disclosure. So it's going to balance the privacy risks versus the benefits of disclosure. I expect there'll be a cutback in what's actually released to the public. And with that, that's the conclusion of my presentation.
Thank you, Rich. I appreciate that. And Dustin, could we move to the hot topic panel, please?
Oh, well,
sorry, legislative update. I apologize.
Yep, no worries. So I'll just provide a real quick legislative update, what's going on here in Sacramento before we get to the main presentation. So quick note about, if you're not familiar with the legislative calendar in California, last Friday, the 21st, was the official deadline for the introduction of new bills in California. And there's approximately over 2,200 new bills that have been introduced in the last couple of weeks. So as you can imagine, our lobbyists and every other lobbyist in the state is kind of scrambling right now to make some sense of, what the landscape is going to be like for the year. So there's, at this point, there's also many placeholder bills that are going to be amended in the next couple of weeks with some more substantive language. So likely at our next quarterly webinar, we'll have a lot more detailed information about what bills we're following and what are some of the main threats for this year. So I've got just a couple here that I'll touch on briefly. So AB 1905 by Assemblymember Chu. This deals with mortgage interest deduction. So in short, it would, if the bill passed as it's currently written, it would reduce the acquisition indebtedness from $1 million or $500,000 in the case of a married individual to $750,000 and $375,000 respectively. It would also only allow deductions for principal residence, no vacation homes or rentals. The author, from our perspective, from early meetings with him, he feels that deduction only helps the wealthy and not enough help for low-income owners. The additional revenue they expect to collect would be targeted for homeless programs. It does require a 2/3 vote. However, if you're familiar with the landscape out here, Democrats do have a supermajority. So they could get something like this to pass if they all voted for it and held the party in check there. So moderate Democrats, though, hopefully from our perspective, moderate Democrats are not going to want to support this measure. We currently oppose it as an association, and we expect to get a broad coalition to help us oppose it. And looking forward to sort of working with the author and seeing what we can do to either mitigate the damage on this one or defeat it outright. So that's AB 1905. Currently, that's in the in first committee in the Assembly in the Housing and Community Development Committee. SB 908 by Senator Wieckowski. This deals with debt collection issues. It creates a new licensing scheme for debt collectors under the Debt Collection Licensing Act, which will be focused with the Department of Business Oversight. So our sort of early analysis and review of the language shows that the author took many of the CFL provisions and state student lending provisions to create this new license. There is we are working to get a express exemption for companies that are licensed under the DBO, the CRMLA and CFL lenders and DRE lenders, for those who are sort of collecting debt with their own borrowers. So we're working with that. And from our understanding, the United Trustees Association is working with their members to get similar exemptions there. So there's a lot of work to be done on that one as well. It's not a great bill on it as it currently stands. And so we'll be working closely with the author and some other trade associations to make sure that we get some work done on that one. So we'll have an update at our next webinar for sure on that one. And then finally, I'll make just a brief remarks on the CCPA draft regulations. We got a new version earlier this month, and as it turns out, the next set of comments are due today by 5 o'clock. So the California MBAs joined the Western Bankers Association and the National Mortgage Bankers Association in drafting and finalizing a new comment letter that will be submitted today. And just if anyone would like to see that letter or like a copy of the letter, excuse me, you can email me, dustin@cmba.com, or you can call our office and get my information. And then tomorrow I'll have that letter available, and then I can send it to you if you have any questions or just would like to see that. So that's all with the legislative update. At this point, we're going to switch to our main presentation. So forgive the fumbling around here, but we're going to switch to our main presentation here, and I will turn it over to our presenters.
Good morning, and thank you for joining us. This is Sandy Shatz. In December at the Legal Issues Conference, we presented this topic, Thank you very much, Dustin and Ian, for inviting us back to revisit some of the issues we had talked about before. I'm not able to advance. There we go. So I'm being joined today by Ashley Fickel and Jennifer Gray, who were introduced earlier today. And we'd like to start and go over the following topics for our program. We're going to look at a case pending before the California Supreme Court, look at the Sheen versus Wells Fargo bank case, look at issues under the Telephone Communications Protection Act with respect to litigation and how it's impacting our industry, look at data breach class actions, deference and preemption issues, and since this is a program on hot topics in mortgage class actions and high-profile litigation, we'll look at the top and look at the United States Supreme Court cases that impact our industry. So let's begin with Sheen versus Wells Fargo Bank. Ashley.
Thank you, Sandy. Good morning to everyone, and thanks for joining us. The Sheen versus Wells Fargo case is currently pending before the California Supreme Court. This is an important case for the industry. Lenders and mortgage servicers have long relied on the old rule in California that they do not owe a tort duty of care to their borrowers. And in the emergence of the loan modification era following the events of 2008 and the emergence of federal programs, the law has developed and a split in authority has existed now in California for some time, with some courts finding that mortgage lenders and servicers do owe their borrowers a tort duty of care when they're entering into loan modifications and otherwise negotiating their loans, and another line of cases that have held that no such duty exists. So on the one hand, we have the Alvarez and Daniels cases, Alvarez being a 2014 case that held that lenders and servicers do owe a borrower a duty of care when they're negotiating a loan modification. And then the Luares case, which was a 2013 case, which held that a lender does not owe a borrower a common law duty to, quote, offer, consider, or approve, end quote, a loan modification. So Sheen was another case that you see in this area, and very common allegations, very typical for those of us who litigate in the state courts and federal courts here in California. Sheen alleged that Wells Fargo owed him a duty of care to, quote, process, review, and respond carefully and completely to the loan modification applications that he submitted. He alleged that Wells Fargo did a number of things incorrectly in connection with reviewing him for a loan modification application and handling his delinquency, and those those alleged breaches included failing to respond to loan modification applications, sending letters to him suggesting that his loan had already been modified, there was no need for him to take action, phoning his wife, who apparently was told that there would not be a foreclosure sale of his home, by sending him correspondence that incorrectly described his loan, told him that his loan was unsecured, and then there was an allegation that his loan had been assigned to a subsequent servicer without that servicer being alerted of the status of the loan modification application. So this court, this case went all the way up to the Court of Appeal in the Second District, and the Second District agreed and followed the Luares holding, finding there was no duty of care, and really kind of made some very important points that have been touched on in other cases in this space, but really were fleshed out in the Sheen opinion. First of all, acknowledged that there was a divergence of views in state and federal court on the duty of care, that there's really a widespread of opinion on that issue. Acknowledged that the majority of states do not impose such a duty of care, and then also went outside the mortgage context to find that a tort duty shouldn't really exist in cases involving pure economic loss. And then also kind of went ahead and took on the policy argument that imposing a tort duty in a financial transaction would erode the integrity of the transactions and lead to unintended consequences. In other words, they're concerned that we're looking beyond just the four corners of the bank's agreement with the borrower. And then obviously signaled that the Supreme Court should take a look at this split in authority. So right now, the Supreme Court granted review in November. The opening brief has been filed. Wells Fargo recently obtained an extension to respond to the opening brief. And really why this case is going to be important for the industry is, it's going to finally provide the Supreme Court an opportunity to clarify, the scope of a duty if it even exists, and really could potentially limit certain financial exposure in large non-economic damage cases for claims like emotional distress and other remedies that just aren't available when you're dealing with a breach of contract case. On the flip side, if a tort duty is found, you could see this spreading to other jurisdictions where, recall, the majority of jurisdictions do not impose this type of tort duty. So other states do like to look to California law, and that could lead to the spread of this concept of a tort duty in other states. So it's an important case to monitor. It's one we're watching closely, and we should have a decision hopefully by the end of this year on that. The next topic I was asked to cover was the Telephone Consumer Protection Act. That's another important statute that really has become hotly litigated all over the country, including in California. It's a case that really, a statute that really has affected the industry. We've seen thousands of nationwide class action filings each year. Many of those lawsuits have been aimed at financial institutions. The law has been very fluid because there is changes at obviously the trial court and appellate court level. The FCC often will weigh in, and then obviously Congress. So it's a very hot issue. Everyone has received unwanted calls on their cell phones. So this is a statute aimed at mitigating that. And because of the manner in which it was drafted and the fact that it hasn't been revised in recent years has led to a lot of confusion. So it has created a lot of problems for operations such as financial institutions who use contact with customers on their cellular phones or by text message, in the context of origination, using, those calls and text messages for marketing purposes, as well as in just servicing their loans and, connecting with their borrowers. So there's been a lot of pitfalls for the unwary in this area. So a couple of the hot issues right now in the last year have been wrong and reassigned number calling. So, folks who have, abandoned their cell phone number and that cell phone number has been recycled, and the new owner of that number has been contacted but didn't consent to be contacted on their cell phone. In 2019, we saw a number of those cases. Ultimately, most of those cases have been favorably resolved for defendants. They've been able to establish that on a class-wide basis that you can't really ascertain who a potential class would be. The FCC in December of 2018 tried to come up with a creation of a reassigned number database, but implementation of that has been delayed into this year, so still things are kind of moving slowly in that area. We still do not have a good definition of what an automatic telephone dialing system is. That direction continues to remain fluid, and courts are really wrestling with the issue of whether an ATDS should include modern-day dialing technology, or whether it's just enough that the ATDS is capable of randomly and sequentially generating numbers, or if it actually has to have that capability. So, and have to be used in that manner. So, still a lot of unresolved issues in this space. We've also seen a judicial trend following the Spokio decisions. There have been a number of TCPA cases where defendants have argued that a simple call or text message doesn't constitute an injury sufficient to confer Article 3 standing. Those cases, unfortunately, do not really exist in the Ninth Circuit. It's been a tough jurisdiction for defendants in these cases, but you can see there have been some favorable cases in other circuits, notably the 11th Circuit, where a plaintiff just receiving a single text message wasn't sufficient to confer Article 3 standing. And then also another case where class members who did not make a request that the defendant stop calling them lacked Article 3 standing to sue in a certain situation where the defendant allegedly did not require an internal do not call list. So a lot going on with the TCPA. We've also seen a big trend in loan origination and the use of third-party lead generators. Those have been very tough cases. You know, in the traditional sense, mortgage originators who buy their leads from third parties have been sued, and there have been a number of decisions that have held them vicariously liable for TCPA violations by their lead vendors. There have been real issues with establishing consent that was obtained by the lead generators, hard to prove later in the case, especially when you're one or two transactions removed from the original generation of the lead. So that's the Telephone Consumer Protection Act. And, you know, we see a strong correlation with some of the issues raised by the TCPA with data breach class actions. Data breaches, you know, obviously have posed for some time an immediate litigation and reputational risk on a nationwide and class-wide basis. There have been well-publicized cases. Data breach defendants have had some more solid defenses. Again, the lack of standing, the fact that there was just a data breach didn't equal harm to consumers. Again, really focusing on the requirements that a potential class show real injury. And there have been good class defenses, so it hasn't been as, you haven't seen as much litigation like you have with the TCPA. But, you know, data breach standing issues still remain unresolved. There's a big split among federal courts as to whether a party who's been subject to a data breach has Article 3 standing. There's a fairly significant split. And just last year, the Supreme Court declined to hear that question in the Zappos case. So, again, lots of unresolved issues that we expect will work their way through the court system this year. Again, because this is a fairly new area, we haven't seen a lot of certification jurisprudence. But, you know, typically, again, the arguments against certification focused on the differences in causation and damages, how each individual who's been subject of a data breach has had potentially been harmed in a different way or in a way that they're not able to approve. So there have been a lot of cases that have held that, you know, the common issues did not predominate over individual issues in that setting. Dustin mentioned earlier the California Consumer Privacy Act. This is now in effect, and we're beginning to see lawsuits roll in. This gives now California residents an avenue to recover statutory damages that didn't exist previously, allows a recovery of $100 or $750 per incident, or actual damages in data breach cases. The CCPA obviously provides some other consumer protections with respect to notice and the sale of personal information, but those are not presently privately actionable. We expect that the plaintiff's bar will test this issue, though, about the non-data breach claims under the CCPA, and that's beginning to percolate in the court system. The CCPA does apply to financial institutions. There is an exemption that some would argue really carves out most of the data that financial institutions hold. Others believe that this is not a very strong exemption. But you know, the CCPA, again, always applies to information held by a covered entity. So the CCPA, even though there is a GLBA exemption, there could be an issue with respect to data that was not obtained during the loan process. So there are a lot of issues that still need to be worked out, and an understanding of what the full scope of the GLBA exemption will ultimately be. Again, the definition of personal information under the CCPA does not apply to de-identified or aggregate data that financial institutions may hold. So if it's not able to be traced back to a particular individual, you're not going to see that applying. This next slide is just really for informational purposes. On the red side, you're talking about information that would be typically covered by the GLBA and arguably subject to that exception. And then to the right in the blue heading would show information that a financial institution would typically hold that would likely not be subject to a GLBA exemption. What is the data breach class action issues, going forward in the CCPA world now that it's in effect? I think it's important to note that this removes some of the prior hurdles to bringing a data breach class action. No Article 3 issues like you would have in federal court. So obviously that's going to be an important issue for state courts to wrestle with if the individuals, the plaintiffs, have to show some articulated harm. Again, but the CCPA already provides for statutory damages, so there's no requirement to show any actual damages, which will lead to an easier route to class certification. It's not all bad news. The CCPA does provide a right to cure, and in the data breach context, an important affirmative defense. If a defendant could show that they had implemented reasonable security procedures and practices, that will act as a defense. So that's different than the current law. So lots of exciting developments to watch for in this space as well. I believe now we're going to be turning to Jennifer, who will be talking about the National Bank Act.
Thanks, Ashley. Well, I'm going to talk about I'm going to begin with talking about a group of a dozen or so cases pending mostly in California and New York courts, beginning with the Ninth Circuit decision in the Lusnak versus Bank of America case. In these cases deal with preemption and federal agency deference, which are hot topics not just in the consumer finance arena, but across many, many industries and issues, including student lending, privacy, data breach, fintech, net neutrality, FDA issues, interest rate exportation, which is the Madden issue, and many, many more. And fundamentally, all of these cases, preemption cases, involve who gets to make and enforce laws in a particular area, the states or the federal government. And these issues are leading to a tremendous amount of litigation right now across state and federal courts everywhere, again, on a host of topics. The Lusnak versus Bank of America decision specifically deals with OCC and HOLA preemption, and it pertains to state laws requiring the payment of interest on mortgage escrow balances. As we'll see as we get into this a little bit, these cases are unusual as preemption cases go because of sort of many layers of Supreme Court decisions, Dodd-Frank, a lot of factors that come into play that don't typically come into play in preemption cases. But they're also troubling because courts are holding banks liable for not following state laws that the OCC had for years opined in the form of formal regulations the national banks weren't subject to, and now banks are forced or facing significant liability to compensate borrowers for years of not complying with state laws that they didn't believe that they were subject to. Just as a little bit of background on preemption, cases sometimes talk of preemption as sort of a judicial creation similar to deference, which is another hot topic right now. But preemption has its base in the supremacy clause of the Constitution, which states that the laws of the United States shall be the supreme law of the land. The preemption doctrine is just a vehicle the courts use for enforcing the supremacy clause. As you know, there's express preemption, which occurs where a statute specifically says that it exempts or state laws, regulated entities from state laws, or it contains an express preemption provision defining the scope of what state laws are preempted. If there's no express preemption, courts can still find implied preemption of certain laws. This occurs where it is evident, for example, with field preemption, it's evident that Congress left no room for states to supplement the laws that fall within the scope of federal law. Field preemption is somewhat rare. It's much more common for courts to find preemption based on conflicts. The conflict preemption exists if compliance with both state laws and federal law would be impossible, or if compliance with the state law stands as an obstacle to the accomplishment or execution of federal law. Regulations are subject to preemption to the same extent as federal laws, so long as the regulation is within the scope of the agency's authority to enact laws under the enacting statute or the implementing statute. So typically, if there's an issue of conflict preemption, courts will look at the original statute, the enabling statute, to confirm that the regulation was within the scope of the agency's authority, and if it was, then we'll go on to look at whether there's a conflict between the federal law and the state law. And so basically, if an agency passed a law saying that XYZ companies that it regulates can't do a particular thing, and a state law then comes along and mandates that those companies do that thing, it's a pretty straightforward preemption analysis, so long as that federal regulation was authorized within the agency's scope of authority. If there's a conflict, if there's some sort of obstacle to complying with federal law, the state law has to give way under the supremacy clause. In the mortgage context, much of the preemption litigation over the years has focused on National Bank Act, and HOLA preemption. The National Bank Act authorizes national banks, as you know, to engage in various banking activities, including making residential loans, subject to restrictions and requirements that are prescribed by the OCC. The National Bank Act also created the OCC, gave a broad authority to enact laws pertaining to national banking and lending. In the Supreme Court decision, Barnett Bank, the Supreme Court held that although the National Banking Act doesn't contain express preemption language and does not evidence an intent to occupy the entire field, the National Banking Act preempts state laws that significantly interfere with the powers of national banks. In other words, identifying that the appropriate type of preemption to apply the NBA was conflict preemption. In 2004, the OCC published a preemption rule, which was issued after notice and comment, clarifying the applicability of state law to national bank operations and identifying the types of state laws that would be preempted. The OCC's regulation sets forth the general standards that, except were made applicable by federal law, state laws that obstruct, impair, or condition a national bank's ability to fully exercise its federally authorized real estate lending powers do not apply to national banks. The OCC regulation then went on to identify specific categories of state laws that national banks could operate without regard to. Specifically, a national bank may make real estate loans without regard to state law limitations concerning, and there are about 14 different topics. One of those topics or subject matters was escrow accounts, impound accounts, and similar accounts. So for years, courts cited this regulation as authority for finding that state laws pertaining to escrow accounts and any of the other things on that list were preempted. And there was very little controversy or dissent over that interpretation. In the years leading up to the enactment of Dodd-Frank, some regulators at both state and federal levels argued that lax regulations by the OCC, including its broad view of preemption, had contributed to the financial crisis. This in turn led the drafters of Dodd-Frank to include in Dodd-Frank a section reining in the OCC's ability to preempt national banks from state laws. So Dodd-Frank creates a category of laws called state consumer financial laws, which is defined in Dodd-Frank and is fairly broad. And under Dodd-Frank, state consumer financial laws are preempted only if, and then it sets out a whole new preemption standard doesn't correspond to any of the previously established buckets of preemption. So under Dodd-Frank, state consumer finance laws are preempted if, one, application of a state consumer finance law would have a discriminatory effect on national banks in comparison with the effect of the law on state charter banks, and two, the state consumer financial law prevents or significantly interferes with the exercise by national bank of its powers, which is a restatement of the Barnett Bank standard. Dodd-Frank also required that any preemption determination be made by a court or by regulation or order of the OCC on a case-by-case basis, meaning that the categorizations that the OCC could no longer categorize buckets of state laws that would be preempted. But it retained, as I said, the Barnett Bank general standard. So one additional point of Dodd-Frank, it also specifically said that the OCC's determinations of preemption on preemption of state finance laws would be subject to more deference. Let me just flip the slide here. Without going into too much detail on deference, because it's very complicated and also a hot area of litigation right now. Traditionally, I think I had to. Oh. Dustin, I don't know if you can move the slides back to the deference. Oh, there it is. Okay. Thanks. I think this is going in the wrong direction. So Dodd-Frank held that OCC determinations of preemption would only be subject to Skidmore, which is the lowest standard of deference. Normally applies only to informal agency opinions, not formally promulgated regulations. So that was quite a change as well. But because Dodd-Frank had retained Barnett Bank as the overriding preemption standard, the OCC did not view Dodd-Frank as changing preemption, OCC preemption, in any significant way. The OCC revised its regulations to track the language in Dodd-Frank, but it didn't issue any substantially new positions or instructions to national banks as to change their way of doing business or following or not following state laws. So all of this changed, and for a number of years, really there wasn't a whole lot of litigation involving OCC preemption post Dodd-Frank. All of that changed, though, in 2018 when the Ninth Circuit decided Lusnak versus Bank of America. In Lusnak, the plaintiff sued I'm trying to get back to the Lusnak. Okay. In Lusnak, the plaintiff sued Bank of America for not paying an interest on its mortgage escrow account balance under a California state law requiring banks and mortgage companies to pay 2% annual interest on escrow balances. Bank of America filed a motion to dismiss, arguing that the NBA preempted this law because it interfered with federal banking operations, citing the OCC preemption rule that included or expressly indicated that state law limitations concerning escrow accounts were preempted. In the Ninth Circuit, the district court dismissed the case on preemption grounds. The Ninth Circuit reversed, holding that the NBA did not preempt a state, California, the state law requiring on escrow balances because the state law did not substantially interfere with the defendant's national bank powers under federal law. Specifically, the court pointed to another provision in Dodd-Frank involving TILA, which required creditors to pay interest on escrow accounts if prescribed by applicable state or federal law. The court took this as suggesting that Congress did not intend for the NBA to preempt state escrow interest laws, or that it would be unduly burdensome for federal banks, national banks, to follow state escrow laws. But the panel went on and held, or the Ninth Circuit went on and held, that the California law had never been preempted, even before the enactment of Dodd-Frank. It said that the OCC's view of what was preempted was entitled to no deference whatsoever, and that even if it was the OCC or the defendant had a very high burden of showing that a law substantially interfered with national banking operations, and that the defendant in this case had not satisfied that burden. Bank of America sought an en banc review. The OCC filed an amicus brief taking issue with the panel's reliance on Dodd-Frank's amendments to TILA, arguing that those provisions couldn't influence the issue because they went into effect after the borrower had obtained its mortgage, and also arguing that the criticism of its regulations was baseless and that numerous courts, including the Ninth Circuit, had sustained the agency's interpretation of Barnett Bank for many, many, many years. The Ninth Circuit refused to reconsider its decision. Bank of America filed a petition at the Supreme Court, which refused to take the case, which surprised many people. This past October, Bank of America settled the case on a class-wide basis. About a dozen or so other cases challenging non-payment of escrow, interest on escrow balances have been filed. At least one has been certified, class certified. In all of the cases, courts have followed Lustenac and rejected preemption-related arguments. Some of the cases deal with HOLA preemption, so they're a little bit different, but the outcome is the same, with courts appearing to reject any preemption-related arguments. And again, there are probably about a dozen or so cases in California and New York, and if you want to look up any of those cases, there's a series of JP Morgan cases. McShannock was a recent decision. Himes versus Bank of America. Kivett versus Flagstar Bank was a case that was recently certified. So these cases raise, I think, a lot of problems for banks in terms of reliance on National Bank Act and HOLA, because there's no limiting principle here in terms of, well, what are banks allowed to rely on in terms of OCC guidance as to all of the different buckets that the OCC has described as preempted under its past regulations. The courts seem to just be giving no deference at all to the OCC's rule, even though it's not just an opinion, it was an actually promulgated regulation pursuant to notice and comment. And normally a regulation would be subject to normal, preemption, conflict preemption standards without really a deference aspect to it. For example, had the OCC enacted a regulation stating that national banks shall not pay escrow on interest, it's hard to see how state laws requiring the payment of interest wouldn't be preempted just under a normal conflict preemption analysis. So I think that there are a lot of issues here that haven't been fully explored or addressed by all the courts yet. On top of that, there's a lot of decisions coming out from the circuit courts and the Supreme Court on deference and preemption that may factor into the direction of these cases down the road. But for right now, it's concerning because, again, it's not just interest on escrow, but really any state law where banks in the past have viewed or relied upon OCC's preemption regulation is now, up in the air as to whether courts would continue to hold those laws as preempted. So just want to talk about sort of a proactive use of preemption as well as a defensive use of preemption. The normal case, again, the preemption analysis isn't as complicated as the Lustenac cases, which had, again, Barnett Bank and Dodd-Frank and a whole lot of layers of authority sort of factored into the analysis. But in the normal case, there's just a federal law, a federal regulation, and then a conflicting state law. And I think we're starting to see some entities, some companies, businesses, and trade associations using preemption proactively to challenge new laws that are going into effect, new state laws that would present conflicts with federal law to which they're subject. So, for example, in this recently filed complaint, CDIA versus Gruel, this filed in the District of New Jersey just in October, a credit reporting trade association seeking an injunction to block a New Jersey law that would require credit reporting agencies to make credit file information available to consumers in Spanish or any other language that the state New Jersey Department of Consumer Affairs determines, and there will be a minimum of 10 other languages, or 12 altogether, that CRAs may be required to make credit reporting information available. The complaint alleges that the New Jersey law is preempted as a matter of conduct preemption, which is new, not very typical, because the requirement by regulating the manner in which the CRAs provide disclosures to New Jersey consumers interferes with its conduct with regard to the fulfillment of its other requirements, and as a matter of conflict preemption because the requirement conflicts with its obligations under the FCRA. It also argues that the law violates the First Amendment. So this was just filed, so we haven't yet seen how receptive courts are to this, but it's a good example, I think, of a proactive or non-defensive use of preemption. Turning quickly to, probably only have a few minutes left, some other issues. Class settlements, diverging trends here in the Ninth Circuit. We have very divergent trends that we're seeing among federal courts and class action settlements. As you're probably aware, federal judges have been very skeptical over recent years of big class-wide settlements that give little relief or remedy to class members. Judge Alsop in the Northern District of California recently issued a standing order which barred parties from even discussing class-wide settlements prior to class certification. That standing order was taken up to the Ninth Circuit, which upheld it and allowed that standing order to stand. So that is a rule in the Northern District, at least in front of Judge Alsop. The Northern District of California has also issued procedural guidance for class action settlements. On the other hand, we've seen the Hyundai and Kia fuel economy cases, courts trying to find ways to reach settlements, class action settlements, where more strict interpretations of certification rules might otherwise not allow. So in the Hyundai case, for example, the court said that even where traditional or strict interpretations of predominance requirements for class certification could not be met, class actions can be settled on looser grounds where there may not be predominance, or there may be mixed, issues of various state laws, competing state laws, conflicting state laws, and the like. In some other circuits, we've seen the development of negotiation classes, again, designed to facilitate class-wide settlements. So there's at once attempts to restrict class-wide settlements to make sure that there are benefits going to the members. At the same time, new devices being created to try and facilitate class-wide settlements. A few other noteworthy decisions that we probably don't have time to get into much detail, but happy to answer any questions about, are listed on the next slide. Knoll versus Thrifty Payless, rejecting strict class-wide certification ascertainability at least on the California state law. Frank versus Gauss, which dealt with Cypre awards, but ultimately spoke more to the issue of standing under Spokio. FTC versus Credit Bureau Center, interesting decision from August, which held in the Seventh Circuit that the FTC lacks authority to obtain monetary relief under the FTC Act, even though it had been using or relying on the FTC Act to seek and obtain monetary awards, restitution, and the like. a cert petition was filed in that case recently. So that was a sort of a surprising decision. Let's see here. I think that's the end of my slides. Yeah. Okay, Sandy, I think that you're going to turn to Supreme Court decisions before we come back to CFPB.
Well, thank you. Thank you very much. We want to talk briefly about the U.S. Supreme Court decisions impacting our industry under the high-profile litigation section. The Supreme Court has decided 5 cases this term. 2 of them impact our industry, Rotkiske and Ritzen Group. In Rotkiske, it's a Fair Debt Collection Practices Act case where the ultimate issue came down to is the 1-year statute of limitations 1 year from the date on which the violation occurs, or 1 year from the discovery of the date on which the violation occurs. In this particular case, Rotkiske owed a credit card debt. He was sued. The debt collector did not have his proper address, could describe him, and served someone else, discovering the error, dismissed the lawsuit, and refiled it a year later, served the same wrong person at the same wrong address, and obtained a default judgment. Rotkiske didn't learn of this until 5 years later, when he attempted to obtain a mortgage and was denied because of the default judgment. So he sued, asserting a violation of the FDCPA, claiming equitable tolling. The lawsuit was dismissed on the grounds it was time barred, and they were setting up a split in circuits. The Third Circuit said, nope, it's time barred, and the Fourth and Ninth Circuit said equitable tolling. The Supreme Court, looking at the various discovery rules, said, no, the plain language of the statute says the claim is to be filed within 1 year from the date on which the violation occurs. There is no discovery rule. The Supreme Court acknowledged there was a fraud-specific discovery rule exception based on an equitable doctrine which was not asserted and therefore not discussed. A second case impacting our industry is Ritzen Group, Inc. versus Jackson Masonry, LLC. Here we had a motion for relief from the automatic stay that was denied. The underlying facts, Ritzen attempted to buy Jackson's land and the sale fell through, and Ritzen sued for breach of contract. After preparing for trial, on the eve of trial, Jackson filed for bankruptcy. Ritzen moved for relief from stay and it was denied, and Ritzen didn't appeal within 14 days. Instead, he filed a proof of claim. His claim was resolved against him through an adversary proceeding, and once the judgment on the adversary was entered, he then appealed from both the decision denying relief from stay and the adverse decision. The district court said the relief from stay appeal was late and denied, and on the merits affirmed the decision below. The Sixth Circuit affirmed that, and the Supreme Court granted cert to resolve when a relief from stay order is appealable. It turns out the court, after reviewing the underlying statutes, made the decision in looking at a bankruptcy case, which is a collection of various controversies, each of which standing alone would be a separate action, decided that a motion for relief from stay, once it's final, whether it's granted or denied, is immediately appealable. So if you are bringing a motion for relief from stay against a borrower and the court denies the motion, if you do not appeal within 14 days, unless the case is dismissed, you're deciding your claim in the bankruptcy court. It's a minute to the top of the hour, so I want to look at one more case that is currently pending in front of the Supreme Court. Oral argument is scheduled for next month in Seila Low. The essential issue in that case is the constitutionality of the composition of the CFPB, single director. The U.S. is opposing the constitutionality of the CFPB the way it's set up. A separate attorney was retained to represent the interests of the CFPB's constitutionality. Congress has intervened. Many amicus have filed briefs, and there'll be a large Supreme Court event going on March 3. Some of the issues include whether to separate out the single director and make it a commission, whether to say the entire Dodd-Frank Act CFPB is unconstitutional, or anything in between. We've included in the packet cases impacting our industry that are currently pending before the Supreme Court to determine whether the certiorari petition should be granted. These cases are interesting, and if you wish to weigh in with an amicus brief to find out if any of these matters are worthy of Supreme Court time and attention in your time, that would be a great thing. In addition, I want to bring to your attention a pending TCPA case before the U.S. Supreme Court. And it's not a TCPA direct issue, it's a content-based. Can you make a rule based on the content, and therefore it impacts our due process Bill of Rights? So that's where we are now. Dustin and Ian, I want to thank you for bringing Ashley, Jennifer, and me back for a quick presentation on hot topics. Top of the hour, and got to turn it over to you.
Okay. Well, thank you to everybody who joined the presentation, and thank you to the presenters for giving everybody a resource that they can drill down on in order to navigate this area of law to the extent they can. We are going to have to postpone the questions and discussions part because we run over the time a bit, but if you would like to email those questions to Dustin or me, we will circulate it amongst the presenters and hopefully get back to you.
And Ian, this is Dustin. Thank you for moderating. Thank you to our speakers. And just briefly, a reminder that the webinar, as always, is recorded and will be posted on our the California MBA's YouTube channel here later this week. We'll also have it posted on our website. And then a reminder that if you're a member of the California MBA and or a member of our Legal Issues Committee, we'll be having our next members only conference call Thursday, March 19th at 2 p.m. So if you're interested, please email me, dustin@cmba.com, and I'll get you all the information. And if you are currently a member, you'll be receiving an invite here in the next couple of weeks. With that, I'll thank again our speakers, and we'll see you next time. Thanks, everyone.